State of Iowa versus Emmett County. Tell us where you went to high school, Mr. Miller.
I'm Zach Miller. I am also an Island by choice. I went to Clayton High School in St. Louis, Missouri, and played baseball. May it please the court, counsel. This court should sustain the writ of certiorari and assess the costs for a special master conducting a judicial function of privilege review to the judicial branch. Costs are only assessable based on a statute or inherent authority, and a judicial function, there's no statute that authorizes shifting the cost for a judicial function to a party.
Where it's included in the state's judicial budget? I mean, would this be a first time to have the judiciary pay for something like that? If I know there's a dispute as to whether or not it's a master, but assume it's not.
I don't think the particular label on the technology provider matters. I think what matters is that it was engaged in a judicial function, and I do think the judicial budget is for paying for the judiciary carrying out.
On that it's not the same, and that's the argument that's been made by the other side. Let's assume that the court would decide no, it's not a special master.
Again, I don't think the label is important. I think the function that was being carried out is important, and so
let's assume that it's not a special master because the court decides it's not a judicial function.
So if you don't think that the review for privilege is a judicial function, and you think that it's the prosecution prosecuting, I mean, I think that there probably you still have an abuse of discretion by the district court in assessing the cost to the state for another party's privilege review. I think that is.
Can I ask you a question about what happened? It's not clear to me what the vendor did. So as I read the record, it was really just kind of an IT vendor making the emails more accessible or easily reviewable. But they didn't actually do the privilege review. They just provided the documents to the court. Is that right?
Partially correct, Your Honor. So what happened was the district court who issued the warrant undertook the privilege review and couldn't sift documents based on who had sent them. And then the provider went through and separated documents and then released documents that were determined not to be from the emails that the defendant claimed privilege. And if you look at the cases from the federal courts, releasing documents to a prosecuting team is the judicial function of resolving a privilege claim.
Maybe back up and see how we got here. Originally, you all were willing to have a taint team, right?
Yes, we were willing to.
You were willing to make the whole thing a prosecutorial function because you were subpoenaing these emails from a third party, and you were concerned, and I think you may have had an ethical reason to be concerned. You didn't want to be just plowing into privileged emails that you had no right to review. So you were willing to go out, take your busy lawyers, their time, which is also money, and have them, and were you going to have the crew that built the pyramids, do this thing that the judge wasn't able to do, or were you going to hire a vendor to go through the emails? How was the state going to do it?
Not sure, because we didn't have a taint team that was ordered by the court to review the documents. I think that there is litigation software that our office probably has a license for that would have aided the review of the documents. But I do think that if you look at the federal cases, when you use a taint team, the courts are uniform in saying that it's inappropriate to have a taint team turn any documents over to the prosecution team absent a judicial officer confirming that they're not privileged. And that's what happened here.
And that's what the judge is willing to do that part. The problem is that, the problem is really who pays for this technical phase. And apparently the state was originally willing to either use its software, or if its software didn't work, pay for it, right?
Agreeing to pay for something is a different question of what functions being executed. And if you look at the record here, the order appointing the technology firm ordered the firm to turn over the documents that weren't from these emails. And the federal cases say that that is resolving a privilege claim, which is the judicial function. If you look at the state cases that we found from Missouri and California, it's the same thing. You have, one of them is jail calls, where the issue is the defendant speaking with his lawyer in the jail calls? And there's a special master who reviews all of that, and then the court said that you cannot assess that cost to the prosecution because it's a judicial function. There's no statute that allowed that. Same thing in California for a search warrant executed on a lawyer's office. And part of that was reviewing emails.
In cases, doesn't California have a statute that govern that? And so my question is, does Iowa have a similar statute?
California case, they decided the statute didn't govern the type of review that was going on there. There was a regime for auto insurance fraud that allowed for these prosecutions. It was partially funded by the insurance industry, but they determined that didn't apply, and the court had inherent authority to appoint a master, and that master was conducting a judicial function that the judiciary was obliged to pay for, and it couldn't be shifted to the prosecutor to carry out a function of determining privilege claims.
Practical matter, what happens? Let's say, all right, so the defendant doesn't want a taint team, right? We have that, we know that. You don't want to pay for the courts hiring a vendor to do this technical sorting through. And what if the judicial branch says, we're not going to pay for it? You're the ones that need the access to the information. The defendant's not asking for it, and the courts don't care. So why isn't it ultimately the state's responsibility to solve the problem?
First, I think that it is the defendant asserting the privilege here. If the defendant had not asserted privilege, this wouldn't be an issue. There'd be no judicial question to resolve. And in fact, a co-defendant who didn't assert any privilege over their email account, this issue didn't arise. So that's the first thing. It's not just the state doing that here. And the second thing is there's other times where the state can't use evidence until the judiciary makes a decision. A motion to suppress would be a good example. The state can't use evidence that's subject to a motion to suppress until we show that someone's constitutional rights weren't violated. But if the court tried to order the state to pay for the law clerk time and the judge time and holding a hearing and taking evidence and issuing an order, that would be improper because there is no statute, there's no inherent authority to do so. And
Practical question. So these are the defendant's emails, right? Why couldn't the judge, and I understand that Mr. Buller advocated for a taint team, or why couldn't the judge just say, look, we're going to image the hard drive, defendant, you're asserting the privilege, flag the emails you think are privileged, I'll review them, and we're done. Why wouldn't that have worked here? And then the defendant would have the laboring oar of doing the document review, and all the judge would have to do is kind of look through a privilege log. Why wouldn't that have worked?
different solution. I think it might be a solution that you could use going forward, with the caveat that I would say, and you suggested imaging it, so you keep the original not subject to being returned. I think that there's a problem when you return evidence that's seized from a defendant via a judicial order of a search warrant. But I think that that would be a solution in a different case you could perhaps use. It wasn't what was used here. What happened was a third-party technology provider was serving as a master to conduct privilege review, resolve claims of privilege, and release the documents to the state, at least that weren't privileged. In federal courts, say that's the judicial function, and nothing allowed that cost to be shifted to the state.
That vendor? Because as I read it, it looked like...
An order appointing the vendor.
I want to make sure I have this timeline right. First, it was going to be the judge that looked at all of them, but because of a technology issue, the judge couldn't do it, right? Then the state says, we'll have a taint team do it.
So first, when the state was seeking the warrant, they go to the issuing judge, who was a district judge in this case. And the district judge and Mr. Buller were deciding if a taint team or a judicial officer would be better here. And based on the record from the hearing on this issue, the judge ultimately decided that the judge reviewing it would be the better course here for the potential issues raised that could come down the line. At the point that the judge had tried to sift through these emails, so then the judge in the warrant said, once the warrant's returned, the defendant needs to give me a list within 10 days of the warrant, of the return being, filed, of any privilege claim. The defendant claimed marital privilege in 4 email addresses, I believe. Then the judge tried to search through the emails for the email addresses that the defendant asserted the claim on, and
From now.
I mean, obviously, I have no idea what the technology hangup was there, but it was apparently impossible. She consulted with court IT. I don't know if that is the judicial district, if there's a central IT, if there's both, what happened. But it was insufficient to enable her to search these emails effectively, at which point she discussed there had been, at that point, a judge specially assigned to this case. She discussed with that judge. They set the matter for a hearing. Before the hearing, the state and the defendant had discussed practical solutions and discussed the possibility of appointing a third-party technology provider, and then the district court ordered that provider to be appointed, and that the provider search the emails, that it turn over any emails it deemed not from those email addresses, thereby resolving the claims for those emails.
Did the state also agree to prepay the vendor?
No, we contested who would pay.
Order,
We can.
Emmett County will agree to advance the cost of digital intelligence. Is that not correct?
Order appointing that said that, but reserving the right to both parties to contest payment. And there was another order entered 10 days. Well, the order wasn't entered 10 days later. The parties had 10 days to argue about who should pay, at which point the district court made a final determination that the state, not Emmett County, should pay for the third-party provider, at which time maybe that cost could be shifted to the defendant upon a conviction.
I guess, is this assertion true that Emmett County did agree to prepay or advance the money to digital intelligence? Was that done? And now we're just arguing about the assignment of the cost and whether or not, okay.
Paid by the sheriff. Yes, and then the question is $1,000. I believe it's like $2,946 or something.
$3,000?
What would happen if a party couldn't pay it?
In terms of
They don't have the $3,000, but those are privileged emails. What happens?
is because deciding a claim of privilege is a judicial function. The judiciary is obliged to resolve the claim.
To resolve a technical obstacle, is the vendor like a court-appointed expert? Are we governed by Iowa Rule of Evidence 5.706?
That rule here. That rule, there's not a ton of decisions on it in Iowa, but if you look at the federal authority on that question, you are allowed to, you basically treat them as a witness. You can cross-examine, you can call them at a hearing, they present evidence. That wasn't what happened here. The expert was assigned a job. That job was to review for these emails and then give the emails that it determined weren't privileged because they weren't subject to the emails that the defendant said to the state, give the emails that were in those lists to the court. The court then made another cut of those emails, and that's standard practice. If you look at INRI grand jury subpoena from the Sixth Circuit, there a court said that there's generally 2 steps to a privilege claim: determining what documents fall in the umbrella of things that are asserted the privilege, and then ultimately determining the second step of if they're privileged. In both parts, they assigned a special master to conduct that function. Other courts have said the same thing.
If everything had happened as you say, and the only change is the vendor handed the emails over that were obviously not the ones that were requested to the court, would we even be here today? Are we just talking about one step that was different? Because I'm struggling with how the judicial branch can get stuck with this.
Yeah, so I do think that having the third-party vendor decide that some of the emails are not privileged is a judicial function, and had that not been the case, the court might have had discretion to.
Court of that, hey, Judge, if I would just, if the state would just hand you those documents to the vendor.
Your Honor, we've done a lot of research in it. I think that it wasn't, I mean, we're at the Iowa Supreme Court, right? Like, I don't think the answer is abundantly clear. We certainly weren't trying to trickily foist the cost onto the court.
Down below to stick the judicial branch.
For example, the court didn't, bring anything like that up. Neither did the defendant, and we did what we thought was the best in the moment to both try to protect the defendant's rights, reach a solution to this issue, and
What you just said. So are you saying it might be a different case if the court just hired a vendor and said, I want you to convert these into something I can read, a text file or something. And then the court actually did the privilege review. But here, the vendor effectively did the privilege review by carving out all the emails sent to or received from particular recipients.
That you could assess the cost if, you know, the court like had to go buy a software program to a party. I don't know that there's any statute that allows it. I think for, like, for example, a taint team, if the taint team doesn't make the ultimate determination of any document, you can assess that, you might have discretion to assess that cost to either party or apportion it between the parties. But because, you know, and also in the first instance here, the district judge who issued the warrant adopted, and I'm sorry, I see my time's expired, so. Yep. The district judge who issued the warrant undertook the review, attempted to use the judicial branch technology. I don't think you could make the state pay for the time of the IT of the court department or the defendant pay for that either. And the same is true here, and that's especially true because ultimately the provider made a judicial determination that certain documents weren't privileged.
Your time, but so the argument for the less than $3,000 is judicial branch, who is funded by the state, must pay instead of the state.
No, I appreciate that the state has multiple different entities and ultimately it's state money, but I think that as this argument maybe shows, different people are protective of their budgets and we all have jobs to do. And, you know, so I appreciate your point though, Your Honor.
Time. I mean, this is, you know, we have 2 days full of cases, and this is a case about the Attorney General's office not wanting to pay a $3,000 bill.
As well. But yes, I appreciate that it's a dispute over $3,000, but it also, I think the most important, I think the most important thing is clear guidance on what to do when this comes up in the future, when prosecutors are trying to protect privilege, so we know what to do and how to not trample on people's rights.
We should do. I mean, suppose we didn't want to get involved in any of this. We don't want to hire anybody. We don't want to go through electronically. Don't want to, you know, let's assume our computers are down, which, you know, happens sometimes.
That if the court had approved a taint team, then obviously the Attorney General is going to pay for the time of the people who did that, or the county, whomever does it. And then the court is going to have to go through and review the documents that go there. A defendant might object to that and suggest a different procedure. I think that that wouldn't violate the law. And I think that in that instance, the court would be responsible for reviewing the emails. It's ultimately going to have to look at all the emails, but subject to the prosecuting office saying, here's what we think no, here's what we think maybe, here's what we think yes. So maybe you more efficiently use that time and the emails have been segregated, but you still are going to have to look at a lot of emails in a voluminous case. And I don't think that that is avoidable. And I think that the time that the court has to use to do that can't be assessed to a party. So we would ask that you sustain the writ.
And for our students here, this is a dispute about $3,000, but this court selects its own cases and fills its own docket and schedules its own arguments.
Thank you, Your Honor.
Point that out, but just so the students know.
Thank you.
May it please the court. My name is Martha Lucey. I'm here on behalf of Craig Merrill, and my office was appointed to defend the district court's ruling. Mr. Merrill didn't want to pay $3,000. He didn't want to pay even more than that amount of money to defend the district court, and so my office has been appointed. I think this case is probably easier than the average dispute regarding whether it's a special master or it's not. Mr. Merrill is the privilege holder. He has the ability to agree to a filter protocol. And that is what he did in this case. The state did not seek to obtain emails to and from Mr. Merrill's attorneys. They agreed that they were not trying to get those emails from 4 different email addresses to and from. The district court only ordered digital intelligence to segregate those emails. They agreed on this. The only dispute was the cost. Digital intelligence is not making a privilege determination. That's already been done. It's been done. State agreed, we don't want those emails. We're not fighting about them. We just don't want to pay.
So after they segregated, there was not an additional review. It was just if an email involves one of these 4 email addresses, the state just didn't want it, put them away, don't include them in the production.
Shows, Your Honor. I'm at a disadvantage. I'm not trial counsel. And to clarify, Mr. Merrill has not gone to trial. He's not been convicted of anything. So what has actually happened is very unclear to me, whether, this is the first I've heard today that, yes, they actually have, the sheriff had the emails, got it from digital intelligence. My review of the docket is I haven't seen where the district court has done any type of review because there's not a dispute.
The judicial function, it was just a technical computer, hit the right buttons and you segregate the email addresses of the lawyers.
Position, because if you look at LAF, I think it's very clear. California, that required a hearing. What that hearing actually entails, I'm not 100% sure, but a hearing is a judicial function. And you look at the Missouri case, and the opinion is not that clear, but Westlaw has the briefs filed by the parties in that case. And the county attorney is very upset because this special master didn't do what he was supposed to do by determining privilege. And so if the special master is actually determining privilege, that is a judicial function. Where here, we have the district court saying, everybody agrees that these 4 email addresses, the state doesn't want them, Mr. Merrill's asserted privilege. It's possible within that group, maybe there isn't necessarily attorney-client communication that would not be privileged. But nobody has said, we disagree with this, so Judge, you need to look at these emails now.
This I'm looking at the order from August 8th of 2022. Where I guess the strict reading of this is it's not privilege review. It's just a direction to segregate email by email addresses. So it's your position then this more was just like a vendor technology function and not privilege review.
That's why I say digital intelligence is not a special master at all.
I get a little hung up is if these documents had been subpoenaed directly from your client, I think your client would have been on the hook to do any review for privilege. So what is it about a search warrant that makes it different, puts it in a different category? Because they're sort of in the hands of a third party.
Number one, with a search warrant, Mr. Merrill didn't know that this search warrant was even happening until they would have received the order from the magistrate saying, tell us what your privileged, what email addresses this would come from. The state indicates in their brief that we should follow, that this court should follow the procedure used in Ray grand jury, which was a subpoena ducasticum for, I think, it was for grand jury, but from a third party where the defendant asserted privilege that the third party, his former company, had those emails. That's a subpoena. If they had gone to get the emails directly from the defendant, he definitely would have gone through, did the privileged log and said you can't have these things, but they weren't in his control. And so at the end of that opinion, the district court said, or the federal court, I'm not even sure exactly where, in Ray grand jury, I think it was the circuit court, said, we think that the defendant could have to pay these costs because he would have done that in the normal course of business if they had actually subpoenaed directly from him. But the court also left it to the sound discretion of the district court, did not actually order the defendant to pay those costs.
Why wouldn't the defendant be responsible for the cost, just generally speaking, because it's the defendant's privilege. He's asserting it. So if you kind of go through the fact patterns, the state could have executed the search warrant, obtained the emails. The defendant doesn't raise any issue, so there's no cost, and the documents are produced. If the defendant wanted to do a privilege review, the defense team would have done it, and that would have been the defendant's cost, right?
If you look at the transcript, Ms. Campbell actually said, I think Mr. Buller is speaking and said on page 11 of the transcript from July 22nd, on page 11, Mr. Buller says, we talked about it. I'm paraphrasing. I think we probably aren't comfortable with each office doing it. But I think that puts in a spot where we have to work on a proposed order. So the state offered, the defense offered, but neither side was okay with it. And, from federal cases, it's pretty clear filter teams done by the U.S. Attorney are very much disfavored because there is that chance of leak. And putting my prosecutor hat on, I don't know how I would feel about defense counsel filtering things out either if I've sought this warrant. They may be trying to hide something. That's why in civil cases with this privilege log, they assert this, but if the other side says, no, we think that those are not privileged, it then goes to a judge for a judicial determination.
Done here. Why couldn't the judge just say, we're going to image this, defense team, you review it, make a privilege log. If anything's contested, I'll resolve the dispute. And then there's no risk of documents being destroyed, metadata being damaged, and the costs are allocated where they should be. Why can't we do that?
In this case, Ms. Campbell did offer from the transcript. I mean, I don't know this personally, I wasn't there, but it appears that she did offer, and that was not the AG was not okay with that. And the court chose this route of a neutral person, neutral company, who presumably is going to just use a computer program, pull them out, and then Mr. Merrill consented to the filter protocol that the non-lawyer communication emails could go directly to the state. So he agreed to that.
Fall within 5.706, the rule of evidence on court-appointed experts. I'm thinking you're saying it's not an expert or a special master.
And I equate this more to where the state wants, the state gets a search warrant, they get a surveillance video. And now they have a problem because the video is not very clear. So they may want to hire somebody to filter out that video. That's not a defense cost.
We get a video, and we can't process it in our courtrooms, and we go back to we get a law enforcement officer video. And I think typically what our judges is they go back to the prosecutor and say, make this in a form where we can read it.
Player. You're supposed to include a player that will play it. Yeah, I believe so. Actually, I know so, Your Honor. It's in the rules. Because my office generally has hopefully solved those problems for you before you get them. If we can't play them, you can't play them.
And the only function of the digital company, they were told those 4 email addresses, right? That they had nothing to do with that decision? Okay, so they were told these 4 names, these 4 email addresses, go through, scrape this pile of emails, and make 2 piles, 4 protected email addresses and everything else. And then according to that order on August 8th of 22, once they've segregated them, the ones that were not segregated, which means not the special email, was supposed to give it to everybody, to the parties. And the ones that were segregated were given to the court. Is that correct? And then their job was done? There was no more involvement by that company?
My knowledge, no. Based upon the record, no.
Had no decision-making regarding which pile I put certain things into?
As far as the record shows, no. And I don't disagree that, you determine what material documents are privileged. That was done. That was done up front. The court determined that. State said, I don't want them. And then if there's a dispute, then the judge has to go through and determine whether the documents are privileged.
The reason why the initial judge couldn't review the documents, as I read that hearing transcript, it didn't seem like it was so much a technology issue as there were 5,800 emails, and the way they were presented meant the judge had to click through them individually, and that seemed inefficient. And I didn't read this as like a player problem that sometimes we have, where it was just inaccessible. It was just cumbersome. And does that matter?
I think it matters as to how this is going to happen. You know, if the government had sought a month's worth of email, I believe it was 7 years, almost 7.5 years of emails. And, you know, anybody that emails, that's a whole lot of email, because that includes deleteds too. So in my understanding is that the magistrate tried to do a search function and it didn't work. And talked to the IT people, and they're like, we think you're changing the data, which could be a problem. She had a copy. So, I mean, I think that's probably good. But given that the amount of data and the inability to do an easy search, I think she said that she had to go through 3 functions to even get the email open. She had to do like 3 clicks for each email. And she was not confident that she was pulling all of the emails that she should be pulling with the search. You know, for future cases, which I know that's probably why we're here, really, if there is an assertion of privilege, the judge is going to have to determine that. Can the judge or the judicial branch get an IT specialist to be able to segregate those emails prior to then reviewing them? I don't think that's a judicial function. The actual review and ruling is the judicial function. In normal course, the court authorizes a search warrant based upon probable cause. Judicial branch doesn't pay for the cops to go execute it. The judicial branch doesn't pay for DCI to analyze it.
Appropriate for the district court to deny the search warrant if the state did not agree to, on its own, remove the privileged documents?
But for the AG telling the court that there would be privileged documents, I don't know if it would have been on anyone's radar for the reviewing judge to know that there's necessarily privileged documents. So would it be appropriate to deny it? I think it's appropriate to do what the judge did, is this man has had lawyers for a number of years, because this was an ongoing investigation for multiple years, according to the record. So it was smart that people recognized that there could be privileged communication. But the warrant only authorized the state to obtain non-privileged documents. It didn't authorize the state to have those attorney-client emails. So to the extent you could just deny the warrant entirely, if there's probable cause, I don't think that's probably appropriate. I see my time is up, Your Honor. May I finish and make sure I've answered his question?
Anybody else has questions, they'll jump in.
Have I answered your question, Your Honor?
More general question. Just generally speaking, in Iowa, the defense usually pays for the cost of litigation, even in appointed context. So the lawyer fee, the cost of experts. Within that kind of framework of the defendant bears the cost of defense, why should there be a carve out here? Because ultimately it's the defendant's privilege and the defendant's asserting it, and he doesn't have to. The state could just get all the emails, and it is what it is. So why should the state or the branch necessarily bear the costs of assisting the defendant in asserting the privilege when we wouldn't in any other context?
Determination of privilege is a judicial function. So if he actually asserted that privilege and the state had not agreed that they didn't want those emails, the judge would have to go through and determine whether these emails are privileged. defendants don't pay the cost of investigating them. You know, Mr. Merrill was private pay at this point in time. He was paying for his defense.
Judge makes a privilege determination based on a party's assertion of the privilege. The judge, in my experience, and if I were on this district court case, doesn't actually do the work of doing the privilege review. That's what the lawyers do. So why should the judge and the state have to bear the costs of actually doing the legwork for the defendant's benefit?
And again, that's where we have some sort of disconnect between civil and criminal, because there's a civil rule for subpoenas. But this isn't a subpoena, this is a search warrant. Defense had no, I mean, they have no advanced knowledge. They don't know that this is even happening. Let's face it, the district court judge who was assigned did not know this had happened because it was in a separate case, in a separate search warrant case, different judge, and only by happenstance did the assigned judge find out that this was happening because they happened to talk at the judicial conference, which I believe is where Justice Waterman presented the new rules of civil evidence. So I don't think the idea that the defendant has the ability to do a privilege log when they're not involved. You know, if he'd been asked, do you want to do a privilege log? Then the AG would have said, no, we don't want him to look at this stuff. And he would have said, we don't want the AG to look at this stuff. And here we are. And I see my time is quickly counting up. I would ask that you affirm the district court.
Can you start with that same question that I asked of Ms. Lucey, where when I look at the document, the order, and it says exactly those 4 email addresses? Help me understand. What did that company do that had anything to do with deciding what could and could not be released?
Documents are turned over without further review. That is a judicial function. If you look at in research,
Or that there needed to be another hearing. The hearing had already been held.
is that the order told the provider to turn over the emails that weren't to those 4 addresses. That is a final privilege determination as to those emails. When you look at the federal cases, in research warrant, Ritchie out of the Southern District of Mississippi, in Verpuri, the reason taint teams were disfavored there, not disfavored, they were ruled that it was an error by the district court to use them, was because the taint team turned over emails that were not from the email list that the privilege claim was of. In turning those emails over to the prosecution team was an exercise of the judicial function that the taint team usurped for the executive. That is why those procedures were struck down, because turning over those emails that weren't claimed was a judicial function. In the order appointing digital intelligence here, ordered digital intelligence to turn those emails that weren't from those 4 addresses over to the state. So that was a judicial function. That is what happened. Then the district court reviewed the remainder of the emails for privilege, turned over a few that weren't, as it turned out, and kept the rest. Well, didn't keep them, gave them to the defense, but not the state.
Pieces to that. The second part sounds clearly like a judicial function. I agree with that. The first part, just get me off of the disk these emails. That there's no exercise of judgment there. Everybody agreed that that's what was going to be done. If there was a taint team, the taint team would have done it. If if the defendant was ordered to do it, they would have had to do it.
Somewhat ministerial, or whatever word you want to use in terms of shifting, the wheat from the chaff. But
a third-party vendor to do it, it's completely ministerial.
This order, and if I tell you, Mr. Miller, you get me emails A, B, C, D, you're the digital guy. That's your job. Go get those emails. I am not giving you any decision-making authority, any review authority. I see nowhere in this order that gives the digital company the power to make decisions. The decision, I already made it. I told you what to do, and I even signed the order.
what emails were and weren't from the privilege claim. That resolved the claim as to all those emails. Those 3 federal cases all clearly say that is a judicial function. Also, if you look at LAF out of California, part of the review of the special master was determining which documents were from emails between the clients and the lawyer's office that was searched there, which weren't, and then there was, potentially further issues of crime fraud exception, et cetera. There was no discussion of, line iteming the cost of the special master separating, and that was okay to the state. But
That was his job, was to do all of it, right? The special master did both.
I think that it was still subject to court review of had there been a crime fraud exception, et cetera. I don't know that it got that far at that point.
Make that determination, those kinds of determinations?
It's clear from the record, or that at the point it made it up to the California Supreme Court, that it happened because the court refused to do any of it until the state agreed to pay half. And since the state refused to pay anything, none of it was done. But there's no discussion in that case of, it would have been okay if you had just said separate the emails or the physical files that aren't from client A, B, and C from those that are, et cetera. It's just the special master for privilege review is a judicial thing. And the same for LAF. The person was listening to calls to decide if they were or weren't from a defense lawyer. And then
Judgment calls that are very different than run a computer software program, these emails are a program, and if it has this email address, put it in one pile, and if it doesn't, put it in another.
the record certainly doesn't say in Carter, but typically a jail call starts with, this is so-and-so person for so-and-so defendant. I mean, I don't know if there's a program that you could have used instead of a person. I suspect there probably is at this day and age. I don't know, but the court certainly did not apportion that cost to the state. It said that's a judicial function. And I think this court should do the same thing.
Ask you to respond to Ms. Lucey's argument that the warrant itself only allowed the county or the state to receive non-privileged emails. Can you respond to that argument?
I don't remember the exact verbiage. What I recall the thrust of the warrant being is that the judge had the state produce all of the data to the judge to review. And at the point, that the defendant could then claim privilege over certain things, and the defendant claimed the 4 email addresses and spousal privilege. And then determining how those claims, fall, we could have gotten it all. If we contested attorney-client privilege, we perhaps could have done so because it was his, email he used in his government work. We didn't, right? But the point is, I don't think we were precluded from getting potentially privileged information subject to how those claims would have been resolved.
It said if the county came or the sheriff came and said, I want a search warrant for all these emails, and the judge said, I approve you getting emails only from a set list of people. So then either the vendor has to do that when they're trying to respond to the search warrant, or it all gets turned over and then someone else has to do that. Whose function? Is that a prosecutorial function?
I guess, I see my time's expired. Thank you. So I'm not sure I exactly track the question, but what I'll tell you is in this case, the defendant was allowed to make the claim of privilege subject, the warrant said that, and then, right.
If the warrant itself said, state, you get everything, and then the defendant said, oh, hey, wait a minute, I want to assert my privilege, that seems to be one thing. But if the warrant said you're only entitled to non-privileged emails, that seems different.
Warrant said anything about what you're entitled to. It specifically made a provision to make sure we didn't have a privilege issue. I mean, I think we'd have a very different case here if we had not done that. We just read everything, and then maybe at some point we're like, oops, current counsel's emails are in here. Let's figure it out. We were being very cautious, and so we have this issue, and I think that clear guidance is what's needed. I think Justice McDonald's suggestion of perhaps having a defendant assert a claim, make a copy so you don't have any forensic footprints, and having defendants pay for it is a fine suggestion. It's not what happened here, so we do have to decide this issue for this case, but certainly guidance for the future would be fine. I think that we don't want to have a situation where we're encouraging prosecutors to not respect potential privilege issues that they might anticipate because they don't want to get in a big fight with counsel. And I would also add that that counsel was willing to review, defense counsel, the emails doesn't mean that there wouldn't have been a big fight about who pays for that also. That issue wasn't, brought up, so I don't know how that would have played out. But you know, I think there's a very good likelihood we would have been fighting about fees one way or the other. And so because this master exercised a judicial function here, this order is illegal, and the court should sustain the writ. Thank you.
State versus Emmett County is hereby submitted.